Hello everyone. See some participants still coming in, but thank you for making the time this morning. Poppy and I will be speaking about our advertised topics. I think we're planning for Poppy to go first.
Yes, just welcome to everyone. Thank you so much for taking the time to join us. As Jonathan said, please feel free to ask questions, and we'll be running a poll as well. But otherwise, I think we get started. They've got enough attendees now. So I'm going to be speaking first, and I'll be talking about making a will and what we can learn from other jurisdictions. So my focus today is looking at the formality requirements in England and Wales, particularly in mind of what's happening with the COVID-19 crisis, which I think has reminded us of the potential for reform. So I plan on looking at the formalities in other jurisdictions and considering how we might reform our formalities requirements in light of theirs. Why do we need formalities? The Law Commission recently did a consultation on will making and has a report that should be coming out soon. In its consultation, it identified 4 functions or 4 formalities. First, an evidentiary function. Formalities provide proof that the will was executed by the testator, and they provide reliable evidence of his intent. Second, a cautionary function. Formalities alert the testator to the serious nature of making a will and cause the testator to think carefully about what they want to achieve with their will. So this could prevent a party from creating a legally binding document without realizing. Third, the channeling function. Formalities mean that the testator's intent is expressed in a way that is understood by those who are going to interpret it, meaning courts and personal representatives who can process the will efficiently and without litigation. And finally, a protective function. Formalities help protect the testator from fraud and undue influence when they're making the will. A signed document is more difficult to forge than an unsigned document, and the presence of witnesses can help protect the testator against any pressure that might be exerted by a potential beneficiary. So, what are formalities for wills in England and Wales? Section 9 of the Wills Act 1837 sets out the formalities. I've put out the full writing of the section on the slide, but in essence, the will must be in writing, signed by the testator or by someone in his presence and at his direction, and the signature must be made or acknowledged by the testator in the presence of 2 or more witnesses who are present at the same time. And each witness must either sign the will or acknowledge his signature in the presence of the testator. Let's take a closer look at what this means. So first, Section 9, subsection A. The requirement for writing. This means no video or audio wills. Secondly, signed by the testator. This means an original signature. There's been no case yet where a typed or electronic signature has been permitted. I refer you there to the case of Lim and Thompson, where a photocopied signature of the testator, even though it had been witnessed by 2 original signatures, was held not to be sufficient. This suggests that an original handwritten signature is required. There's no conclusive authority on the point of digital signatures, but the Law Commission has concluded that digital signatures are probably not permissible. Coming to subsection C, this is the requirement for witnesses. The testator's signature must be made or acknowledged in the presence of 2 or more witnesses present at the same time. The case law indicates that there needs to be, the witnesses must be in the visual presence of the testator. The witnesses don't actually have to be looking necessarily, but they have to be conscious of the act done. This is turning to subsection D. Each witness must attest or sign the will or acknowledge his signature in the presence of the testator. So again, the attestation must be in the visual presence of the testator. And even though the testator need not actually see the witness's attestation, he needs to be able to see it if he chose to. So he needs to be conscious of what is being done. There is one exception to the formalities requirement, and that is privileged wills. These limited categories of people can make wills in writing or orally, and they don't need to be signed or witnessed. The COVID-19 crisis, I believe, has thrown into sharp relief how stringent the formalities requirements are and how there is room for reform. Having a will witnessed by two people in the same room runs the risk of contravening social distancing rules. Beneficiaries also can't witness wills, which means that a member of one's family is likely to be excluded as competent witnesses. The MP Lloyd Russell Moyle suggested in this question that video conferencing and privilege wills could be solutions. The Parliamentary Under Secretary of State responded to this, apologies for the very lengthy text, and confirmed that the government is reviewing the case for reform on the law of making wills, but highlighted that what's happening at the moment has to be put in balance with the safeguards in the law to protect elderly and vulnerable people, in particular against undue influence and fraud, and the importance of having two independent witnesses. He concluded that privilege wills wouldn't be appropriate at the moment, but that other reform measures are being considered. In the longer term, the government is considering reforms to the law on wills arising from the forthcoming Law Commission report on wills. So, what sort of reform could be suitable? Today, I'm going to focus on three ways in which we could reform our formality rules. First, holograph wills. Secondly, electronic wills. And thirdly, dispensing powers. First, holograph wills. The word holograph comes from ancient Greek. It means holos means whole or entire, and grapho means I write. So it would be a will that's wholly written and signed by the testator. In England and Wales, holograph wills still need to comply with the Section 9 formalities, but in some other jurisdictions, they're valid purely by virtue of their holographic nature. This includes some countries in Europe, some states in the United States, and also some Canadian provinces, such as those that I've set out there, including Alberta. In Alberta, they have the Wills and Succession Act, and Section 16 provides that a will may be made in writing, by writing that is wholly in the testator's own handwriting and signed by the testator without the presence or signature of a witness or any other formality. What are the advantages of holograph wills? First, they're likely to be less expensive. If you can write the will and sign it at home, you're probably less likely to go to a solicitor to draft the will. This might make holograph wills particularly suitable for small estates or simple wills. They're also more convenient. There's no need for multiple witnesses who must be present at the same time with the testator witnessing the will. The requirements are also simple, so it makes it easy for people to understand and comply with. Finally, since it's written in the testator's handwriting, it does provide protection against forgery. But what about the disadvantages? First, difficulty locating it. If the testator has executed it on his own and then put it somewhere without telling anyone, the will might never be found, and there will be no witnesses to suggest that a will did exist. It is also most likely to have been drafted without legal advice, and as we all know, legal advice is very important for testators because it informs them how they might best dispose of their estate in the most efficient way. This third point about the testator considering the process carefully, this goes back to the cautionary function of wills. The testator is less likely to consider the seriousness of making a will if they don't have these stringent formalities requirements. It also does not protect as much against the risk of undue influence. If there's no requirement for witnesses, then undue influence may be more likely from a potential beneficiary. And this, of course, can lead to the risk of litigation, which is costly and time-consuming. An example here is the case of Cursed Estate, which I've set out. In that case, there were 6 surviving children who ended up engaged in protracted litigation. This is a case from Alberta. Initially, some of the children disputed the validity of the will, and after the validity was accepted, they turned to a dispute over the interpretation of the will. The clause I've set out there is that Whitehorn can live in the house for a while to be determined by him and his brothers and sisters. The dispute was over what for a while meant. This case demonstrates that first, while a testator may think that it's an easy and convenient way to execute a will by doing a holograph will, it might lead to litigation between the beneficiaries or disappointed beneficiaries later over its validity. The testator might also have thought that his wishes were clear, but in fact, in this case, it caused acrimonious litigation between his children. In conclusion, I would say that the disadvantages of holograph wills outweigh the benefits. There is value in witnesses. They can identify that a will exists, and they can also protect against undue influence. There's also value in having a more formal process, which might make a testator think about what they're trying to achieve and how best to achieve it. I would say that there are other ways of will making becoming more accessible. So, moving on to the next possible avenue for reform, electronic wills. What do we mean by electronic wills? Well, first, these can be wills that are prepared or drafted electronically. This already happens regularly. Then there can also be wills that are executed electronically and wills that are stored electronically. My focus will be on electronic execution, although I would expect this would probably also result in electronic storage as well. By way of a reminder, electronic execution is not permissible in England and Wales. It seems that a written original signature is required, and most likely physical presence is required as well. Where can we find electronic wills? Well, in the United States of America, 4 states have enacted legislation, those being Nevada, Indiana, Arizona, and Florida. And we also, in America, they now have the Uniform Electronic Wills Act. The Uniform Law Commission passed the Uniform Electronic Wills Act in July 2019. This is effectively a model for other states who want to adopt legislation on electronic wills. I've set out here Section 5 from the Uniform Electronic Wills Act, which under this potential act, an electronic will would mean a will executed electronically in compliance with Section 5A. The Section 2 of this Uniform Electronic Wills Act provides for certain definitions. When they say electronic, they mean relating to technology having electrical, digital, magnetic, wireless, optical, electromagnetic, or similar capabilities. So it's clear that the Uniform Law Commission have tried to give a very expansive definition because making room for any possible development in technology there might be. So an electronic will would be one executed in accordance with Section 5A. As you can see here, an electronic will must be a record that is readable as text at the time of signing under paragraph 2. A record means information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in perceivable form. Then it must be signed by the testator or another individual in the testator's name, in the testator's physical presence, and by their direction. That's familiar from our formalities as well. Sign, what does sign mean? Well, under Section 2, sign means with present intent to authenticate or adopt a record, to execute or adopt a tangible symbol, or to affix to or logically associate with the record an electronic symbol or process. quite a complicated set of definitions that are emerging. Turning to subsection 3, this requires for the will to be signed by 2 other individuals who, after witnessing the signing of the will. So reasonable time after witnessing in the physical or electronic presence of the testator. So it's in square brackets because the Uniform Law Commission are providing for the opportunity to adopt electronic presence or not. What is meant by electronic presence? Well, this means the relationship of 2 or more individuals in different locations communicating in real time to the same extent as if individuals were physically present in the same location. So then they can witness it by witnessing the signing of the electronic will or the testator's acknowledgement. So it's quite familiar from the formalities that we have, but this would provide for electronic signatures and electronic witnessing. What are the advantages of electronic wills? Well, we are moving towards a digital world, and wills cannot be the one thing that remain antiquated. We're all familiar now with remote courts, electronic bundles. Surely this is going to be the way that wills are going as well. It would also potentially make will making more accessible for people. Most people have access to the internet, so they would be able to execute it over the internet. At the moment, the Law Commission estimates that around 40% of adults die without a will, so this would be a fantastic way of making wills more accessible. It would also be more easy and convenient for people, as they would not necessarily need to go to a solicitor and would not need to convene witnesses all in one place. Moreover, if you execute it and then store it electronically, depending on the infrastructure, it might make the will more safe and secure as it's less likely to be lost. What about the disadvantages? So first, it might be more open to abuse, undue influence, fraud. There could be an advantage in having the witnesses physically there. Cybersecurity, we all are aware of the risks of the people hacking into computers, and so this could make wills that are electronically stored vulnerable. Finally, and most crucially, we need the proper technological infrastructure to support electronic signatures and remote witnessing. How are testators going to sign these wills? Are they going to type in their name? Are they going to use a fingerprint, a retinal scan, voice recognition? How will witnesses be able to sign the testator? For example, if they're typing their name in, they don't know what they're typing. So careful thought needs to be given to how exactly this would work. And this is seen from the instance of Nevada, who this state actually enacted e-will legislation in 2001. And their e-wills actually require no witnesses, but an electronic signature that includes at least one authentication characteristic of the testator. So a fingerprint, retinal scan, voice recognition. And this is at a very high level, and it means that the wills just haven't been popular and they haven't really been used. I think this shows that we need to ensure that we have appropriate and accessible infrastructure so that e-wills will be regularly used. In conclusion, I would say that this would be a very positive reform, but first we would need to have the appropriate infrastructure. That means a platform which allows for safe and secure digital signature and the ability to witness the execution of a will, say by video conferencing. That is looking more likely. So, third and finally, dispensing powers. Dispensing powers would allow the courts to recognise wills as valid even where they fall short of the formality requirements. There are 2 possible ways of going about this. First, there's substantial compliance. The focus here is on how far the formalities have been complied with. For example, in Queensland, which used to have, as a state in Australia, used to have this legislation, in Section 9 of the Succession Act, provided that the court may admit to probate a testamentary instrument executed in substantial compliance with the formalities prescribed by this section if the court is satisfied that the instrument expresses the testamentary intention of the testator. On the other hand, we have a sort of more of a focus on testamentary intention. So does the will, which fails to comply with the formalities, represent the intentions of the testator? I'm going to focus on dispensing powers according to testamentary intention. I think that this focus accords more with our emphasis on freedom of testamentary disposition, and it would also still cover those instances where there has been substantial compliance, but it would have a wider reach. This can be seen from a case called Grossert from Queensland in 1985, where the court concluded that the document in question represented the testamentary intention of the testator, but concluded that there hadn't been substantial compliance, so it could not be admitted to probate. This is an example of a dispensing power section. This is from New South Wales in Australia. In New South Wales, the Section 6 of the Succession Act requires that a will be in writing, signed by the testator, and with 2 witnesses, like in England and Wales. But Section 18 provides that the court may dispense with the execution requirements for a will, alteration, or revocation. Essentially, what the court does is approaches such an application in 3 stages. So they first must look at whether there's a document. So this goes to subsection 1. This section applies to a document or part of a document. They then consider whether it purports to state the testamentary intentions of the deceased. This goes to subsection 1A, but it hasn't been executed in accordance with the part. And then they assess, this is subsection 2, whether the deceased intended the document to form his will. As you can see from subsection 2, it means the document can form a will, an alteration of a will, or a full or partial revocation of the will, if the court is satisfied that the testator intended that to be the case. So looking at some of the cases where these dispensing powers have been used and unorthodox documents have been admitted to probate. The first case, Tracy and Edwards, there a will was executed, which included a provision saying that I direct my executors to dispose of all my property, both real and personal, in accordance with the audio tape recorded list which accompanies this will. The will and audio tape were admitted to probate. In Re Wilden, the testator left a DVD and a typed document. The DVD footage recorded the testator saying that this is a somewhat of an unofficial last will and testament, as I don't have a written document anywhere at this stage. This is just a fail-safe until such time as I do get something like that done. That was admitted to probate. In Yazbek, the testator very sadly committed suicide, but before then had made an electronic document, and this was found on his laptop, and it was entitled Will Doc. Ryu, this was also a case of suicide, and before the testator did so, he created a series of documents, including one commencing with the words, "This is the last will and testament." That was on his iPhone. Finally, in Re Nickel, again, the testator committed suicide, but an unsent text message was found on his phone, where he directed that his possessions be distributed in accordance with his will. So, what are the advantages of dispensing powers? Well, it gives effect to the testamentary wishes of the deceased. It also allows people who don't understand the formality requirements or can't comply with them because of their circumstances to still make testamentary disposition. But it does not change the formality requirements per se, but it acts as a safety net, which would be policed, I would say, by the courts. But what about the disadvantages? So formalities might be disregarded, people might not bother executing a formal will, but I would say this would be unlikely because there would need to be an application to court. Everyone would still prefer to execute a will if possible. It would also, though, lead to increased litigation, expense, and delay. In conclusion, I would say this is a very positive reform because it wouldn't actually change the formality requirements, which would have an important function and should be the baseline, but it would allow people to make testamentary disposition if they're unable to do so, and it would be policed by the courts. Just a quick recap of where are we now. So Section 9 of the Wills Act still applies. and that requires actual physical presence, it seems, and an original handwritten signature. It's possible that the court might allow video conferencing at a later stage if an application came up, but there's no authority in this. We don't know this. We should stick with physical presence. We haven't had any COVID-19 reform provisions, unlike in Jersey and Scotland, where video conferencing is currently permitted. We're also awaiting the Law Commission's report, and hopefully that will suggest some policy reform.
Right. Testamentary capacity is one of the staple topics of probate disputes. I'm sure pretty much everyone who's listening will have come across it, and probably the vast majority of you will have litigated over it. So I'm going to not focus too much on the basic test, but there is one particular rule which I think is less well known. It's quite interesting and it's moderately controversial, so I think it's worth talking about. But I will be going over the basics briefly, and that's a rough roadmap of what I'll be talking about. I might talk a little more about gathering evidence. There's nothing particularly surprising on that topic, but I'll make some observations about what I think you can usefully do when you have a probate dispute. This is the test. The common law test has been around for a long time. This is a slight paraphrase of the phrase in the judgment. Interestingly, the judge in this case was actually giving direction to a jury, but probate litigation is now very different. The test, however, is still roughly the same. I say roughly because the probate disputes are always in fashion, and there's a huge amount of case law discussing various elements of it. Almost whatever your case, you can find something which is close to it, or you can find some judicial comment which touches on it, and very often comments in different directions. And if you delve into it, it can become all quite bewildering, I find. But this is where you should always be coming back to. This is the core test, which has stood the test of time. I've broken it down to 4 elements. That's actually slightly controversial. There is a school of thought that really they add up only to 3. But I think the better view is 4, for what it's worth. I'll explain that in a moment. The first one is probably the most basic requirement. The testator has to understand the nature of what they're doing by making a will, and what wills do. If they don't do that, they're not going to have capacity to do it. And this basically means a document that will take effect on their death, will be binding on their successors, more or less, and will dispose of all their assets. So that's normally not too difficult to establish. If you're having difficulties with that first hurdle, then you've got a very frail testator indeed. The second is that they've got to understand the extent of the property of which they're disposing. Obviously, that can't be a precise understanding. For one thing, the will takes effect in the future, so things might change. But they need to understand roughly what their estate is at the time they're making the will. You could have some interesting cases where people have assets of really very uncertain value. So if you've got an obscure author, they might leave their literary estate to someone. But then if after they make their will, they become very famous, then the literary estate might become very valuable. I don't know of any cases of that kind. I think the courts take quite a liberal view. The fact that a testamentary gift turns out to be surprising and probably unexpected by the testator doesn't mean they don't have capacity. So this is a broad understanding. For the vast majority of people making wills, the main asset of their estate will be the house, and that's quite readily understood. The third element gives rise to, I think, quite a lot of difficulty, and that's that the testator should be able to comprehend and appreciate the claims to which he ought to give effect. This is mainly talking about moral claims, but of course, if you've got a situation where the testator has promised something to someone, they've relied on it, the testator probably ought to give effect to it. And even if they don't, there might be a proprietary estoppel claim. This does give rise to a lot of difficulty because people who expected or thought they ought to inherit but didn't tend to latch onto it and say, well, they must not have been able to understand and appreciate my claim. So you've got to be wary of falling into that trap. because, as we'll come on to in a moment, the testator is allowed to be unfair. And its question is not whether they do reach a fair understanding of claims on them, but whether they're capable of taking them into account. And the fourth, this is the one which some people say is really just an aspect of the third. And this is that no disorder of the mind shall poison their affections, pervert their sense of right, or prevent the exercise of his natural faculties. There's also a bit about insane delusions, which refers to fixed beliefs that are irrational about people who might inherit. For what it's worth, I think the better view is that there are four and that the fourth one is separate. But it's clearly mainly directed towards the issue of what claims ought the testator to give effect. Because if someone has a completely irrelevant delusion, for instance, if they think the Prime Minister is really a reptile from outer space, that probably doesn't matter, unless there's any reason why they might give money to the Prime Minister. A completely irrelevant disorder is unlikely to affect their testamentary capacity, in my view. Quite an interesting case for all sorts of reasons is Scott and the Vegetarian Society, which involves someone who had a clinical diagnosis, or I'm not sure they'd actually been diagnosed in their lifetime, but the evidence was clear that they were schizophrenic, although there was some debate about the extent to which they were. They were still held able to make a valid will, despite the propensity to create long rambling commentaries in notebooks, because when they did turn their mind to will-making activities, the court found that they were capable of rationality. So I think that probably mainly focuses on being able to fairly take into account and weigh up possible beneficiaries rather than completely irrelevant disorders. But there is a slight debate about that. You still sometimes see in correspondence people talking about the Mental Capacity Act in the context of probate claims. James and James is a case only at first instance, but it's one of several first instance cases. And although they don't all go the same way, I think the majority of them are that the Mental Capacity Act does not apply, and it's still the Banks and Goodfellow test only. And for what it's worth, I find the reasoning in James and James and the other cases which it agrees with quite convincing. Having said that, it's still worth looking at the Mental Capacity Act because it has various pointers about how we understand mental capacity. So I've given the factors from part of the Act. The Act has quite a lot more to say. But broadly speaking, the decision maker needs to understand the relevant information, be able to retain it for long enough, but only long enough, use or weigh it up as part of a decision-making process, and communicate it. You'll notice the Banks and Goodfellow test doesn't talk about communication. That's probably because if a testator can't communicate their intention, it's very difficult to see how they could execute a valid will at all, given the formality requirements. Where this does come into play with probate context is if you reach a decision in the person's lifetime that they lack capacity within the meaning of the Act, then you can apply to the Court of Protection for a statutory will. So it's irrelevant to wills altogether, but when you have a probate claim happening after the person's death, it's really the Banks and Goodfellow test which you need to focus on. Actually, before I move on to this, there's some debate about whether there's much of a difference between Banks and Goodfellow and the Act. There's one fairly straightforward, clear difference, which is that the Act starts from a different presumption. The Act presumes capacity, whereas, as I'll come on to, in probate claims, the burden of proof is on the person contending the will is valid. So the starting presumptions are different. Probably the main difference in practice is that a lot of the Act is about helping someone get into a position where they can make the decision themselves. And that's why it talks about starting with a presumption that they have capacity, and you've got to take into account the steps that could be taken to help them understand before you conclude they don't have capacity. That doesn't really work after they're dead, because then the possibility of helping them to understand and make a decision no longer exists. You've got to decide whether in the facts as they actually happened, the person had capacity then, and the possibility that they could have been helped to be capable is not relevant. That's probably the main difference in practice, I would suggest. Some things that testamentary capacity are not. Although it is relevant whether the will looks rational, that's not the deciding point. The will can be irrational or unfair in all sorts of ways. I've referred to one judicial comment, but there are actually quite a number in the case law. And again, Scotland Vegetarian Society is an interesting one, because the charity which inherited the bulk of the estate, and that was about 80% or so of an estate worth more than £1 million, was the Vegetarian Society. But the testator wasn't a vegetarian. And although the evidence was that he had a fondness for animals and the environment, he himself, there was evidence, was a meat eater. So on the face of it, it was a really strange decision. But in the end, the court found that, as a matter of fact, he did have capacity on the evidence, and it's a question for him who he chooses to give his money to. And of course, you can speculate about reasons why he might have done it. He didn't like his family members very much, it turned out. So he'd given them a very small amount of money. He'd given his friends a bit more. But for all we know, it might have privately amused him to think of their reactions to the will. Or maybe he was more inclined to the vegetarian cause than we know. The case is quite a salutary warning that you can't really see into other people's minds, and you've got to give weight to the fact that people can make all sorts of decisions that's difficult to understand, but that doesn't mean they lack capacity. It is relevant, though, to the burden of proof. In probate claims, the person propounding the will, first of all, bears the burden of proving that it's valid. Obviously, the first thing you need to do is look at the will itself. If it looks rational on its face, then that raises a presumption of capacity. In the first place, the person propounding the will doesn't have to do very much, because it's not a very high threshold to show that a will is rational on its face. But if the will does not look rational, if it's perhaps rambling and contradictory, or does something really startling, or alternatively, if there's a real doubt about capacity for other reasons, the evidential burden can shift back. I've referred to the case of Key and Key, which contains a very clear discussion of the burden of proof. And that was a case where it was found there was a real doubt, so the burden did shift back. And the facts were that testator was of advanced age, 89, and one of the sadder circumstances was that he'd been married for an extremely long time, and he'd been bereaved only a week before. And so that's a case where something other than your more typical psychiatric illnesses was relevant, because we thought that bereavement could have an effect on someone's decision-making capacity. On that note, it's not just things like dementia which are relevant. People can lose capacity for all sorts of reasons, and that can be temporary as well. So if someone is an alcoholic, it's possible they made the will while they were too drunk to make a decision with capacity. Similar things arise with drugs, not just illegal drugs, but perhaps a diabetic might lapse into incapacity for a period of time, while being, in general, perfectly capable. So you do have to focus quite narrowly on the time of execution. The other thing I say there is that he'd radically changed his will. This is something that disappointed parties very often rely on. It is relevant. If someone's radically changed the will and there's no obvious reason why, that potentially suggests a doubt that they're no longer capable of the same reasoning process that led to them to their earlier decision. But they can just change their mind. They don't have to have a good reason to do that. Something that's very popularly raised in probate litigation is the golden rule. And this is a rule of best practice that was suggested some decades ago. And it doesn't have any legal effect, but of course it's an important part of the evidence. And it's a recommendation that when you've got a very elderly testator or one who's seriously ill, because that might affect their capacity, it's a good idea to arrange for a medical practitioner to satisfy themselves that the person has capacity. And what isn't in that passage, but is often also a good idea, is to have a medical practitioner be one of the witnesses to the will. I think in recent years, this seems to have fallen out of fashion a bit. That might be because now people are more ready to accept that even the very elderly have capacity. And it's also probably assisted by the fact solicitors do follow the case law, and the case law contains some comments about how it's a strong thing if an experienced solicitor thinks the person has capacity to conclude that they actually don't. And you don't necessarily need a medical practitioner. That's very true, but for what it's worth, I think the number of probate disputes which still arise are quite a good clue that this should be happening more often, because probate disputes are extremely expensive, and I don't really see much of a good reason to avoid doing it. It can be done quite diplomatically with the testator, although they might be under no doubt whatsoever that they have capacity. They presumably want their will to be upheld. They presumably don't want their intended beneficiaries to have to bear the burdens of protracted litigation about the validity of the will. So a cheap way of making it much more likely those problems don't arise is to get an independent assessment from someone who's capable during their lifetime. That will make it very much harder for someone successfully to challenge testamentary capacity, or even to raise a sufficiently credible case that you have the problem of litigation. It doesn't need to be a GP, although it often is, and I think GPs are quite willing to provide this service for a relatively modest sum. It depends on the position of the testator. For example, if the difficulty with the testator is that they're deaf and blind, then you need someone who's particularly capable of communicating with deaf-blind people to help ascertain whether or not they have capacity. So I think the golden rule should be followed more often than it is. If you've got a probate claim, apart from the will itself, probably the first bit of evidence you should start with is the medical records, if you can get them. And you should always be able to get them, because it's very difficult to form an assessment of the merits of the case without them, unless it's so obvious that you hardly need to. So that should always be pretty much the first step. If you're even contemplating a capacity challenge, or if you think, or if one's being threatened, it's pretty much the first thing you should do. But they won't necessarily tell you the answer. The case law is full of warnings that just because someone has something that might affect their capacity doesn't mean they don't have capacity at the time that matters, the particular time that matters, which is usually execution of the will. But the medical records, assuming the person is in contact with medical professionals, should give you a pretty good idea of their overall state of health. And in the common case where someone's health is deteriorating, both physically and mentally, you can get an idea of what the trajectory was. And it's a good idea to get an expert view of exactly how far you can draw inferences from it. And an expert can probably tell you whether a particular incident is equally consistent with something temporary, like a urinary tract infection is very common and can create a great degree of confusion, but would resolve in most cases quite shortly afterwards, or whether it's more consistent with the person having advanced dementia. And you do need to be interested in the degree of dementia, because someone can have mild or even moderate dementia. I always find that a slightly tricky phrase, but you can be beyond the earliest stages of dementia and yet still have testamentary capacity according to the Banks and Goodfellow test. Apart from medical records, usually one of the most important bits of evidence is an attendance note from whoever was involved in drawing up the will. You don't always have that, of course, if it's a homemade will, but that means homemade wills are harder to defend. But if you've got a professionally drawn will, you'll hopefully have a good attendance note. The quality of the attendance note is very important because very often, as you'd expect, the person who drew up the will say that as far as they could tell, the person was perfectly capable. But you can't always tell at a glance whether someone lacks capacity. They might be good at carrying on a conversation, but yet not have memory of who their relatives are that they might leave money to, for instance. And so the attendance note will hopefully give you an insight into the extent to which the solicitor probed the issue of capacity. And if it doesn't, the attendance note is going to be of much less weight, and those comments about it being a strong thing to come to a different view to the solicitor at the time won't apply in the same way. Because it's so important whether the person had capacity at the time, at the specific time, you can't easily tell that from medical records themselves, which is why I've said they can tell you about the trajectory. But that means you're going to be very interested in lay people who knew the deceased and actually saw them around the right time, and what evidence they can give. Obvious candidates are the witnesses to the will. As Poppy's talk showed, that's not really their function. They're not there as capacity assessors. But if they were there for more than a few moments, and if they spoke to the testator, they will hopefully be able to give you some impression of what they were like right at the time that matters. And that will be important. Again, it depends on how much of an opportunity they had to gather an impression. One advantage is because witnesses can't inherit under the will, they will hopefully be more independent than family members. Other people who knew the testator, their evidence can be important, and it's something you should always investigate. Ideally, it's better if they've got some distance from the dispute. I've suggested friends, carers, neighbours, gardeners, and hairdressers. Hairdressers is just a common one because by its nature, it involves chattiness, and it tends to happen at regular intervals. People often go to the same hairdresser. So there will be a person who can give an idea of how they were in conversation over potentially quite a long period of time. And of course, if they stop doing things like hairdressing appointments that they did before, that might be a sign that their mental condition's deteriorated. But it's worth considering the testator's routines generally. Anything that they did regularly that brought them into contact with people might give you good candidates for witnesses. Things written by the testator are likely to be a good insight into their capability, because in many cases you have a real lack of things written by the testator, because the will instructions form, as there often is, that might have been filled in by someone else in conversation with them. That quite often happens, and it gives rise to suspicion. So you can find something actually written by the testator themselves. That will hopefully be good evidence. Scotland, the Vegetarian Society, is again a good example. There are all these rambling notes which cast doubt on capacity, but there were also some things written by the testator which showed that when he was focused on a particular task, he could be much more rational. Last thing is video. Video wills don't work, but making a video at the same time as you make the will could be really helpful, because then you actually get to show it to the judge if you get to a trial, or you can show it to your lawyers afterwards when they're assessing the merits. And that can be so much more helpful than relying on secondhand descriptions or the little snippets of information you get from records. I don't know why this kind of evidence is isn't more common, because with modern technology, it could be really common. It could be routine in will-making exercises done by professionals, that there's some video where the testator talks through perhaps their reasons for making the will they have, hopefully thereby demonstrating that they've got capacity to make a proper decision. So that's something I'd like to see more. But of course, if you've got evidence like that, you're much less likely to get to a trial. But that's a good thing. Now I'm going to move on to a more specific rule. See if we've only got a few minutes left. What the rule is for is where you have a situation where there's a gap in time between the giving of instructions and the actual signing of the will, the execution of it by the testator. There's almost always going to be a gap of time, whereas you've got a professionally drawn will. But what's interesting, it's ones where the capacity deteriorates between those two events. And the starting point is the testator needs to have capacity at the time of execution. It's not enough in itself if they had perfect capability when they gave instructions, and the will perfectly captures what those instructions were. They need to have enough capacity at the time of execution. You cannot get away from that at all. In fact, the key question which this rule bears on is how much capacity do you need at the time of execution? And essentially what the rule does is say that you might not need to meet the Banks and Goodfellow test completely if you did meet it at the time you gave instructions. And those instructions were settled, and the will you're executing reflects those instructions. And you still know at the time of execution that what a will is in principle, and you know that you want to act on your previous decision, even if you can't remember exactly what it was. The rule is controversial. It was challenged not all that long ago, but the Court of Appeal upheld it. They said they were bound to uphold it, but they also said it was a good rule anyway. So it's only going to be changed if the Supreme Court takes a different view, or if there's statutory reform. Okay, one slight caveat is if something's gone wrong and the will doesn't reflect the previous instructions, the rule doesn't help you, can't save the will. That's fairly obvious, I think. As I said, you still need to be able to understand the nature of the act of making a will. If all you can do is physically sign the page, but you really don't know what you're doing at all, the rule doesn't help you. A more subtle question is how much the testator needs to remember about the instructions they gave. They don't need to remember any detail at all. It does seem that they need to be able to remember that they have given instructions for a will. And there's a case where that was found to be the right analysis. And personally, I think that makes a lot of sense. If a testator at the time of execution can't remember giving instructions at all, it's difficult to say how they can have capacity to confirm that that's what they want to do. They want to make that will. So if you got to that situation, you probably need to resort to the Court of Protection. There's also a bit of uncertainty about how settled the intentions need to have been. The cases on this, the judge tends to reach the conclusion that the testator didn't change their mind anyway. It seems to me that if the intentions were only provisional and the testator had in mind that they were going to have a draft will drawn up, but then reconsider it, then at minimum, they need to be able to remember that that was the case and be in a position to decide whether or not they're happy to go ahead dispensing with the reconsideration they'd intended to do. And even that might not be enough. There aren't really any cases which test it. For obvious reasons, because now you're interested in two moments in time, the moments of giving instructions and the moment of execution. And for that reason, you need to be especially careful with the evidence. It's a more complicated exercise, particularly if you've got the quite tricky situation of a very imperfect state of mind at the time of execution. It's just inherently difficult where someone's losing capacity and has already lost a large degree of capacity to work out just how bad it's got. So they're quite tricky cases when they do come up. That was it. What it's worth, the main advantage of the rule is that it saves wills which would otherwise be invalid. And the main disadvantage is it's complicated and creates litigation. And of course, it creates increased doubt about whether the testator really did want to make that will. Those seem to me the main arguments. Right, that was all I was going to say. But thank you all very much for giving up slightly more than an hour of your morning to listen to us talk. I hope it was worth your time.
Yes, thank you everyone for joining.